Good afternoon or good morning. Thanks again for joining us today. This is I think our fifth in our Labor Spotlight Series webinar series, which is a mouthful. And as we've talked to you about this before, this is a series focused on labor relations issues, and we're trying to be as practical and down to earth as possible. And I think we've got a really good topic for that this time. We're going to be talking about the risks of engaging dependent and independent contractors and temp employees, and specifically the labor relations risk, obviously. And we're also going to be providing another update on bargaining trends, what we're seeing at the bargaining table. So thanks for joining us. Today we have Craig, myself, and Emily joining you. Craig and I will be speaking about the risks with contractors and agency staff, and Emily will be giving you some insights on bargaining trends. So in terms of agenda, we're looking at about an hour. We are going to spend the first half of that on talking about the contracting out issue and use of temp workers. We'll give Emily some time to talk about bargaining trends, and then we're going to leave it open for questions at the end. So please save your questions or type them in the chat as you go, and we will definitely get to them at the end. So on to the first topic. So I think this is an exciting topic, and it kind of goes to the heart of what we're trying to get at with the Labor Spotlight series. We're not necessarily talking about the most cutting-edge Supreme Court of Canada cases here. Some of the cases are old chestnuts that go back that you're going to be hearing about. But the idea is to consider this risk that a lot of our clients, I think, have a little blind spot on. And that is this idea that using a contractor or a temp agency is a bit of a get out of jail free card for unionization, either to become unionized in the first place or to have your union expand its rights within your operations. And it is possible to use those two tools in an appropriate way to reduce risk, but it has to be done very carefully. And that's what we're going to be talking about today, is sort of the do's and don'ts and the risks of different ways employers will use contractors or temp agency employees, and how those can actually be potential pitfalls. And so there's three scenarios we're going to be talking about just at a very high level. And we're going to get into some of the definitions of what these terms mean. So if you're not comfortable with them right now, you will be shortly. So first, we're going to look at when you have a dependent contractor and that dependent contractor becoming unionized. Okay, so there's a question of whether or not they're dependent or independent, and then they can be unionized. The second question is more, the second issue is going to be about the use of a true legitimate independent contractor, but there's still being a risk of unionization through related employer applications at the board. And then the third issue or topic is going to be around the use of temp help agencies. So the three different categories, they're all very similar in concept and they're very overlapping. Dependency is a theme throughout, and I think you'll get that by the end of the presentation. The presentation is focused on the law of Ontario, I note, for those of you joining outside, but the concepts are very applicable to other jurisdictions. So happy to have specific conversations offline with respect to other jurisdictions if that's of interest. Great.
So I will jump in here and talk about sort of the first risk. And it's that first bucket of, independent, quote unquote, independent contractors who are in fact dependent upon the organization. We can move the slide to the first piece. And this is sort of one of those old chestnuts that Russ mentioned. The concepts have not really changed in terms of how do we assess whether someone is an independent contractor or an employee or a dependent contractor. Back in 1981, there's a very famous case called Algonquin Tavern, and it involved burlesque dancers working at various hotels and taverns across the province. And the question came up whether those dancers were employees or whether they were independent contractors. And, the board sort of went through this pretty exhaustive list of factors and criteria that they look at. And that same list gets used today, whether we're talking about gig economy workers or more traditional sort of independent contractor structures. And if we're going to talk about what those factors actually entail, the key is autonomy and the ability to make independent decisions. So there's an exhaustive list in Algonquin, but I'm going to highlight just the most important ones. First and foremost, I think, is the right to use substitutes. So the idea that an independent contractor is a third party who's running their own business. They're an enterprise for themselves. They have the ability and the discretion to determine who's going to do the work and when it's going to be done to a certain extent. So the right to use substitutes is really part and parcel of that. Can they subcontract out the work themselves? Can they identify who amongst their organization is going to do the work? And so that's bucket number one. Bucket number two really is about, again, this concept of autonomy. Do they have the right to say no to work? Do they have the right to reject a request to perform a particular service, or to accept a particular contract, or accept a particular route or order? And the ability to deny that work or to refuse to do it speaks of that underlying issue of autonomy. Structures where people don't have the right to say no, where they don't have the ability to subcontract work, where they are essentially beholden to saying yes to the assignment of work, that tends to move along that spectrum closer to an employee or a dependent contractor. So these ideas, again, they're historical, but they are flexible in how they are applied. I think the biggest takeaway you can take from these old Algonquin Tavern principles, though, is what's the actual degree of independence that is exercised by the organization or the third party in general. And we can move to the next slide very quickly here. But let's talk about these three categories, just so we're all on the same page, right? Bucket number one, you have your employees. The employer is the one who's determining where and when that work's going to be performed. The employer is the one who is supplying the tools and the equipment and the material. That work, can't be subcontracted out to somebody else, can't be assigned to somebody else. And we have those sort of core hallmarks of management rights: the ability to dismiss someone, the ability to hire and discipline someone, to direct the work in all the manners and sort of normative fashion that you would expect. Bucket number one is that employee bucket. Next slide would be category number two, which is the other end of that spectrum, right? Those independent contractors. Again, applying these old Algonquin tavern principles, these are people who are in business for themselves on their own account. They have the ability to say yes to work or to say no to work. They have the ability to subcontract work. They have the ability to work with third parties separate and apart from your organization. So exclusivity of work is a big piece. They are largely determining, how and when and where that work's going to be performed. Ownership of tools and, where risk of profit and chance of loss lies. Those are probably less important factors now than they ever used to be. Really, it's this idea of, are they controlling when and how the work is being performed, and is there exclusivity tied to one organization or another? Importantly, independent contractors don't have the right to unionize under the Ontario Labor Relations Act. That is similarly true, sort of across Canada. Obviously, employees do have the right to unionize. And then we move to the next slide, which is category number three, and it's the dependent contractors. Always think about this as a spectrum. Like, employees are on one end, independent contractors are on the other. And then there's a whole bunch of variance in the middle, and the boundaries upon which dependent contractor status have been drawn vary slightly depending on your jurisdiction. But again, it's the core concept remains the same, and that is whether or not that contractor is economically dependent upon the business or organization, and whether they have an obligation to perform duties for that business. Particularly if there's an exclusive obligation to perform work for that business, or an historical trend line that shows that they've only worked exclusively for one business or another. Those are really determinative factors as to whether or not you're going to be a dependent contractor or not. Again, we've got 40 years of jurisprudence at this point that really can help us lay the groundwork for where we think a particular classification will lie. Dependent contractors, very importantly, they have the right to unionize. So again, even if you hit all these sort of more traditional ownership of tools and risk of profit and chance of loss, even if those factors might suggest independent contractor status, the way that the law has moved towards examining true economic dependence, the degree of autonomy that's actually exercised, is really, really important to determining whether or not these contractors might have the right to unionize nevertheless. And I'll pass it over to you, Russ. Russ has a really good example of how to sort of frame these three buckets.
Great, and I did. Thanks, Greg. I saw there was a question in the Q&A about an example of dependent contractor. So let's switch to the next slide. And I think I've got a good example here. I mean, everyone can relate to having a personal chauffeur. I know Craig and I have our own that drive us around town. So I think it's a very relatable example that we can all understand. So the idea is to give you examples of three categories of workers. So one category, we've got personal chauffeur, the next a taxi driver, and then the third would be a sort of a dedicated taxi driver. And I'll explain each one. It's once again, this is just like a simple kind of tool to remember the difference between the three. So a personal chauffeur, if you had one, he or she would drive the car that you provided, right? You would be provided the tools. You'd be providing them with the uniform. They would have to follow your rules. You would tell them how to drive, what to wear, how to open the door for you, whatever the rules that might go with having a personal chauffeur. If the car got damaged, it wouldn't be the personal chauffeur that's paying for it. It would be you. If you took a route and it took you way out of the way and you got stuck in traffic and it cost a bunch of gas, that wouldn't come out of the personal chauffeur's pay. He would or she would get paid like normal, and you would absorb the cost of that. So that's a very classic example where the personal chauffeur is your employee. Now, let's take it to the other end of the spectrum. Like Craig mentioned, that spectrum is a good way to visualize it. You have a taxi driver. So the taxi driver shows up when you call them. When you don't call them, they're out driving other people around independent of you completely, right? They provide the car. They don't have to wear a uniform. They don't have to follow any rules that you set out. There might be some rules that the government sets out, but you don't dictate the rules. You don't necessarily tell them how to get from A to B. And if they make a mistake, they turn down a road and get stuck in traffic and they sit there for an hour and it costs them a lot of gas, that's on them. That comes out of their bottom line. I guess sometimes you do pay a bit more when you're stuck in a cab, but for sure, second, just assume that the taxi driver basically pays for those excesses. And the same thing, if he can get you or she can get you somewhere faster and it's a flat rate, then he or she will make some more money. So there's that idea of making a profit or a loss, and that being on the taxi driver's own in their own control. The taxi driver could also hire someone to drive the taxi and pick you up and drop you off, and you wouldn't know the difference or be able to complain about that, right? So that's a true independent contractor. It's someone who's in business for themselves, okay? And then this third intermediate category is the dedicated taxi driver. And the way I like to think about it is, imagine if your company just needed drivers regularly to move your staff around. And they reached out to a taxi driver and said, hey, you know what? We call you a lot. Why don't we just get into a situation where you come every morning at 8 and you leave at 5 and you just drive our people. We just need you to be available. So sit outside the building and drive our people. And we're just going to do that. Okay. You own your taxi. You decide the rules. We're not controlling any of that, but we need you every single day to come to us only. So that's this concept of the dependent contractor. They look like an independent contractor in almost every other aspect, except they're fully dependent on you and you're effectively controlling them. And you can see how that relationship evolves over time. If it's a couple of days, they're not so dependent. If it's 10 years or 20 years, they're quite dependent. And if we look at the next case, we can see where that rubber kind of hits the road in a very similar example. So this is a more recent case, Motor Express Toronto. This is a company that was hiring drivers to drive trucks. The drivers owned their own trucks. They had to maintain them themselves, but they could only work for the company that hired them. They weren't allowed to work for anyone else. They weren't allowed to use someone else to drive the truck or hire employees to drive the truck. And they were found to have to follow the rules and routes directed by the company that hired them. And so the board considered the test that Craig had mentioned and applied it to these drivers and found out that they were actually dependent contractors. And it was really that relationship of exclusivity that mattered to the board. And the board found that even though the parties had never intended that relationship to exist, it's totally indeterminative. So it does not matter if there's an intention. And what we've seen in other cases outside the unionist context is it doesn't matter what the parties have written down on paper. You could have an independent contractor agreement that's papered, signed, totally valid in other respects, but it's not going to be determinative of the nature of the employee for the purpose of the Labor Relations Act. What the board's going to do is they're going to look at the true nature of the relationship. They're going to tear it apart and look at some of those factors that Craig had mentioned and that are set out in that case. And I had reviewed with that example as well. And they're going to look mainly for that economic dependence. And in this case, what was really fatal is that the employer really controlled these workers. They weren't allowed to go work elsewhere. They didn't have really an independent standing business. All of their work had to go through the company. And so the board found them to be dependent contractors and they were certified. Great. So that's our first category of worker. Craig, do you have anything to add on that, or should we switch?
No, I think that's the perfect segue into sort of our second bucket. And so if we move forward for a slide, we're going to talk about bona fide and independent contractors who are nevertheless economically dependent upon one organization. Jump forward one more slide here, and we'll talk about a very recent decision from the Ontario Court of Appeal. So this has a bit of a winding backstory to it, but the core of it is that Enercare had a collective agreement with Uniform. That collective agreement allowed Enercare to use third parties to contract out work. It had a long-standing relationship with 3 different independent contractors. And what Unifor did was say, well, look, notwithstanding the fact that you can contract out work, we believe that those contractors are actually dependent contractors and that they should nevertheless be subject to this collective agreement. And we're going to come back to this slide, but jump forward one just so I can look at the provision here. So, Section 1 sub 4 under the Labor Relations Act, it's a related employer provision. And what it says is that the labor board can treat 2 different corporations or 3 or 4 different corporations as one employer for the purposes of the act, if those businesses are under essentially common control or direction. And so, a Section 1.4 application, related employer application, is sort of a mechanism. It's intended as a mechanism by which a union is able to protect its existing bargaining rights and to say, look, you can't essentially double vest these things. You can't have one union business and one non-union business and funnel all of your work to the non-union business to avoid or subvert the union's existing bargaining rights. So let's go back one slide, back to the Enercare sort of summary. So this, the original board decision essentially says, look, of these 3 contractors, 2 of them are functionally economically dependent upon Enercare. So for, 10 years, over 10 years, all of their, well, not all, but something like 90% of their income was being derived from Enercare. They had no public-facing business presence. They didn't work for any other parties. They didn't really even have the ability to say no when Enercare needed them to do the work. So you might see all of the other hallmarks there incorporated. They have WSIB coverage, even if they had branding and third-party marketing services, which they didn't in this case. That functional economic dependence is what gives the board the basis to say, well, okay, we may have 3 companies here, but 2 of them are economically dependent upon Enercare, and we are going to consider them alongside Enercare as one organization for the purposes of the act. Now, it's really important to understand that a Section 1.4 application is a discretionary power of the board. So there has to be some purpose, some labor relations purpose or mischief to which the board is trying to address or remedy. So it doesn't necessarily mean that, a CA will automatically be applied to a different organization. There's still some discretion involved, but this decision really sort of expanded the concept of how, a related employer declaration might start to draw in dependent contractors under one umbrella. So that's the board decision. It gets judicially reviewed at Div Court. Div Court overturns it and says, no, this is an expansion of what 1.4 is intended to do. But Unit 4 appealed that to the Court of Appeal, and the Court of Appeal actually reinstated the Labor Board's original decision, which found that 2 of those 3 contractors were dependent and were related employers for the purposes of the Act. It's a little bit wonky in that, the standard of review at the Court of Appeal for these decisions essentially just means the Labor Board, its decision is internally coherent, it's rational, it's logical. But again, because it's a judicial review and an appeal, they don't have to say that the Labor Board got it right as much as they have to say that it was a reasonable outcome and it was within the board's area of specialty to make this decision. But the upshot of it for us really is to think, again, more broadly and perhaps more nuanced about our contractor relationships, and to really have a better line of sight on where there is true economic dependence. Because to Russ's point, you can paper this however you want, but if your otherwise independent contractor has been economically dependent upon you for 10 years, there is a significant risk that they could be held to be a related employer, and that common control and direction could be found on the right facts. We'll jump forward 2 slides now, and I will pass it back to Russ. Oh, Russ is on mute.
Just to recap, we've looked at 2 examples so far. We've looked at the situation where you've got contractors, and then the board's found them to be dependent contractors, and the LRA specifically allows for unionization of dependent contractors. So you get basically a bunch of employees effectively out of it, right, for the purpose of a collective agreement. With the second situation, where you've got 2 really fairly independent entities, there's some economic dependency in terms of the contractor deriving a lot of their work from the main supplier or entity. But the board found that they were related employers. So they used another mechanism to apply the collective agreement across. So now we're going to look at a third mechanism or risk factor, and that's using a temporary help agency. So now we're really separate, right? We've got 2 really independent entities. The temporary help agency is probably a true independent contractor. They're providing employees to a whole variety of different employers, but they're also providing the employees, obviously, to the target employer of the union. So let's look at the next slide. And a lot of employers use temp help agencies for a variety of reasons. It's not just for union avoidance. Obviously, it provides a lot of flexibility. They can come and go. You can bring them in at peak seasons, like Christmas time for retailers, that sort of thing. And they can be used for specific tasks, like maybe cleaning or maintenance type work, where you don't want to do it in-house. But what the board's asked is, who is the true employer of these temporary workers? And if we go to the next slide, we can see the case, the main case where they considered this. It's from 2004, Atlantic Sugar case. And in this case, the union sought to certify a group of temp workers that had been working in a warehouse and also doing trucking for Atlantic Sugar. But those workers were not employed by Atlantic, which is kind of almost sounds like an oxymoron, right? How can that be? The company, the temp help agency, they did all the salary, did all the payroll, they authorized vacation, they did all the hiring, they assigned the workers to Atlantic and just made decisions on assignment, and they even implemented any discipline. So for all intents and purposes, they look like the employer of these workers. But the union argued that actually these workers were often placed with Atlantic for a long period of time, for many years at a time. that Atlantic was seen by the workers as their boss, and particularly the manager of the warehouse was their boss, and he was the one calling the shots. The workers all wore Atlantic uniforms and appeared to outsiders as employees of Atlantic. And importantly, the board found that through the contractual relationship between Atlantic and the temp help agency, Atlantic was actually setting the wages of the workers because they were basically, they had negotiated a contract. And then when they renegotiated, part of renegotiation was how would the extra pay or charges, I guess the temp help agency charged Atlantic, how would that be going to wages? And how would wages be adjusted? And that was part of the discussion. And the board also found that basically this boss, the manager that the union thought was the boss of the workers, did have effective control over discipline. So he could make recommendations to the temp help agency to discipline these workers. So we put all that together, the board found that Atlantic actually was the employer of these workers, which led to this very strange outcome where you have Atlantic bound to the Teamsters for these workers. Atlantic has to negotiate a collective agreement for these workers, but the workers are not paid by Atlantic. They're paid by the temp help agency. So the board acknowledged that that was a bizarre outcome, but it goes to show the risks that employers will face, because obviously the employer after that had to probably shake up how they operated with these workers. Great. So next slide. We're going to talk about some recommendations now on how to avoid some of these bad outcomes we've talked about.
And we can jump forward one more slide. Again, just sort of a high level recap here. If we're thinking about the principles that are going to go into, your assessment of your existing risk and how to mitigate it, keep in mind classification of workers, very, very fact specific. So it matters very little what your contracts will say, what your service agreements might say. It will matter very greatly how the relationship actually functions. What's the day-to-day management of this contractor relationship? How long has it been in place? What are the reporting lines? How is the work being directed and driven? The mechanics of it is incredibly important, and the way that it's papered is increasingly of less importance. And then also keep in mind, what we're seeing here is that, classic principles, well-established principles that are nevertheless being applied in new ways and in new modalities and new ways of work. And I think the intention, whether explicit or, inferred from the results that we're seeing from cases, is that there is a desire to expand employment-like rights to different groups of workers, right? To try and take some of the risk and vulnerability off of workers and shift it onto employers. And you see that most specifically in the gig economy worker space and the way in which gig economy workers who might otherwise have thought of as independent contractors are nevertheless being classified as dependent contractors and being provided with an avenue to unionization. Again, that same trend line sort of looks at related employer concepts and says, well, yeah, we should also be flexible in how we think about related employers, and economic dependence and exclusivity of work can really inform when and how the labor board will exercise its discretionary powers to declare, two or more entities related for the purposes of the act. So let's talk sort of nuts and bolts for us around what are some mitigation strategies, what should employers be looking at?
Great. So next slide. With respect to the use of contractors, so as Craig mentioned, it's going to be very fact specific. So you're not going to be able to check one of these boxes and then be safe, right? It's going to have to be applied carefully with a total view of the relationship between the contractor and the employer. But here's some general tips. So my general advice is function follows the form. So you should get an agreement, an independent contractor agreement. And like I said earlier, that's not going to be determined of the fact that you have an independent contractor agreement, but it's the content, because the content of that is going to really drive the relationship. So at the front end, if you can tailor the agreement to set out some of the things we'll talk about in a minute, such as non-exclusivity, and you bake that right into the beginning of the relationship, then the relationship should flow in that direction, in a direction that's much safer. So some things to work into the contract, like I said, is the non-exclusivity. And it seems to be a temptation to put exclusivity in these contracts. And I get it. You want the person to be available, at a whim when you need them, but it's really kind of the death knell. So the best thing you can do is to put non-exclusivity into the contract, and you can actually dictate it. So what I actually recommend to clients is you say that the contractor undertakes that they will not rely on you for more than 50% of their business, and they will inform you at any time when it does exceed that amount. And that's, once again, it's not a get out of jail free card, but it gives you some insight into what's happening with the relationship, and it prevents that dependency from being there potentially. If they've got a lot of other clients, the argument that they're dependent on you is much reduced. And that falls into this next point about monitoring the amount of work being provided. You've got to stay on it. There'll be a tendency, I'm sure, particularly at the business end, to monopolize these workers because it's easier. Deal with one person instead of 10, or keep the same person year after year instead of looking for a new person after a year or two and turning them over. But as a business, we really have to step in and say, it's actually important. There's a reason we're doing this. We're turning over, or we're getting different people in. Make sure that the contractors are providing their own tools and equipment. That's usually the case, but be careful about uniforms and things like that. And be careful about requiring them to follow company procedures and policies. And then sometimes you're a little bit of a bind there, where there's sort of a workplace health and safety policy or some safety policies that you might need them to follow. But the key thing is making sure they're not subject to discipline. If there's an issue, it's a contractual issue. It's not a disciplinary issue. And then the last point here is ensure the contractors are not dependent. And that just goes back to what I was saying before about make sure that they're not getting more than half of their work from you, if possible. Okay, next slide. And so these are some considerations with the use of temp agency workers. And a lot of them are similar. You want to avoid controlling the performance of the work to the maximum extent possible. And I know that's difficult because that's kind of the whole point, is you bring the workers in and your supervisors and managers tell them what to do. But if you can have someone from the temp help agency actually in a role that's actually intermediary in some way, that we would strongly recommend that. The workers shouldn't be subject to your policies or disciplined. And you can just report incidents to the temp help agency and they will deal with it. Don't get involved with hiring, training to the extent possible, obviously payroll. And this is a key one, I think, is require the agency to cycle staff through. It's a lot of work. It's training for your managers and supervisors and team leads. You're going to have to do more training to bring people up to speed, or have the temp help agency do more training, ideally. And you might lose good people. But if you're keeping them in there for year after year, you're just sort of burying a problem, and that problem can erupt up. It'd be safer to just hire them as employees and work that out with the temp help agency, because then you know what you're dealing with, as opposed to having this sort of hidden risk that's just sort of simmering under the surface. So those are our recommendations. What I suggest we do is let's switch to Emily right now. I think we're right on time. Let's switch to Emily. She can talk about bargaining trends, and then we've got some questions in the Q&A chat. Feel free to add some more, and then Craig, Emily, and I will work through them after Emily finishes her section.
All right, great. Hello, everyone. So as Russ mentioned, my name is Emily, and I'm an associate in the labor and employment group here. And as we now usually do at the end of these webinars, we'll just be going through some recent bargaining trends. And as kind of the graph and the picture there aptly represents, a lot is going up right now. So from inflation to wages, which is having an impact on how parties are approaching the bargaining process. So while the data in today's presentation, I think, is pretty interesting, it's not necessarily surprising. So let's move to the next slide. So two buckets we'll be discussing today. So we'll be looking at wage trends, both by sector and then by industry. And then we'll take a look at how resolutions are being reached in 2023 compared to the previous year and then pre-pandemic. So moving to the next slide. So starting off, we're going to take a look at wages by sector. And of course, these are some wage trends that we're seeing in times of inflation. So starting off with Q1 of 2023, we can see that the majority of private sector employees are receiving an average wage increase of between 3 and 3.9%. And another big chunk of private sector employees are receiving a large increase of between 5 and 5.9%. And while the majority of public sector employees saw an average increase between 4 and 4.9%, with another large group receiving an average between 3 and 3.9%. Moving to the next slide. So Q2 of 2023 saw the vast majority of both public and private sector employees receiving an average increase between 3 and 4.9%. And moving to the next slide. Now in Q3 of 2023, employees in both the public and private sector received between a 4% and a 4.9% average increase in wages with very little deviation from that range. So not surprising, considering external pressures like increasing grocery prices, increasing mortgage rates, rental rates, all of that is going up. So not a huge surprise that wages are kind of following in that pattern. And you can see the trend has been upwards from Q1 up until Q3. So it'll be interesting to see what happens in Q4. Moving to the next slide. So let's take a look at the overall wage increases from 2022 to 2023. So this is more of a high level, moving from kind of the quarterly insight to an annual insight. So in 2022, we saw a huge concentration. Over 50% of public sector employees received an increase only between that 1% to 1.9% range. Whereas a very large concentration of private sector employees received wage increases between that 4 and 4.9% range. So a pretty big difference between the two sectors in 2022. Moving to the next slide. So if we compare what we saw in 2022 in terms of overall wage increases to 2023, very few employees overall are receiving wage increases in that 1% to 1.9% range in 2023. The majority of both public sector and private sector employees are falling into either the 3 to 3.9% bucket or the 4 to 4.9% bucket. Next slide. So this I thought was an interesting graph to have a look at. This graph shows average wage increases in the public and private sector from 2011 up to 2023 compared to the consumer price index. So in 2020, we can see the consumer price index really starting to take off and kind of dragging average wage increases with it, although wage increases are very much trailing behind the CPI. And although we can see that while at times the average increases in both the public and private sector beat the consumer price index, over the past few years, average wage increases have been unable to keep up, although public sector increases in particular have been rising at a pretty steady rate. So moving to the next slide, thank you. So let's turn now to look at wage trends by industry. We can see in 2023 that the primary industry is leading so far with average increases at that 5.5% mark, whereas health and social services, construction and transportation, comms and utilities aren't too far behind, all with increases over that 4% marker. And in quote unquote last place, we have public administration with an average increase of 3%. So not too much deviation, all pretty much 3% and over. Moving to the next slide. In 2022, construction led in terms of wage increases at an average of 4.4%, while trade and finance, manufacturing and education and related services are at 3% or just over 3%. And in 2022, we can see that the industry with the lowest increase is health and social services at 1.4%. So notably, while the primary industry had the largest increase in 2023, they didn't make it on the podium, even so to speak, in 2022. Next slide. So in 2021, going back to the previous year, we can see that all of the industries are kind of hovering between that 0.8 to 2.2% on the whole, a lot more modest than what we've seen in recent years. So you can kind of see in 2021 might be that cliff where we're starting to see increases above that less than 1 to 2% range. Next slide. And trends were about the same in 2020. So with the greatest average wage increase at 2.2% in the construction industry. And I think all this, really just highlights how much average wage increases have increased over the last few years. Again, largely not terribly surprising, and in response likely to external economic forces that we're continuing to see. Next slide. So let's take a look at how resolutions are being reached in 2023 as compared to previous years. So far in 2023, obviously we have the last few months of 2023 left. We've seen the majority of resolutions being reached by way of arbitration, with direct bargaining and conciliation about tied for second place. And we can see work disruptions are sitting at a very low 4.4% for 2023 so far. Jumping to the next slide, we'll take a look at 2022. So comparatively speaking, a large chunk of resolutions in 2022 were reached due to work disruptions at a pretty high rate of 22%. Arbitration in 2022 was still a big contributor to resolutions at 30.4%. And what this may suggest is that people had a larger appetite for work disruptions in 2022, while the continued inflationary environment in 2023 may be dampening people's appetites for any sort of loss of steady income. Next slide. And then comparing all of that to pre-pandemic, so 2019, we can see work disruptions sitting at a very low 1%, with mediation, conciliation, and direct bargaining all being big contributors to resolutions pre-pandemic. So some overall conclusions from these trends, we can see that as inflation continues to increase, dragging wage increases with it, although, at a much slower pace than what we're seeing in the consumer price index at the moment. We can see that wages are continuing to rise quarter over quarter in 2023. So again, it'll be interesting to see if Q4 follows that same pattern or if there's any deviation from that. We're seeing more wage increases in that 3 to 5% range across industries, as opposed to the more standard 2% inflationary increase that we've typically seen in the past. And then, of course, 2022 saw a big jump in work disruptions, which we're not seeing in 2023 as that's kind of cooling off. And perhaps that's due to lower risk tolerances given the continued inflationary environment. So that's all from some bargaining trends. So I'll pass it back to Russ to answer any questions you guys may have.
Great, thanks, Emily. That was awesome. So we can go on to questions. I'm going to go to the next slide there. And there's some in the chat already, or I should say the Q&A, not the chat. And happy to go over these or get back to you if we don't get to them, but feel free to add some more. So one question was the risk to employers if employees are paid as independent contractors, but they're actually, I guess, employees. So there's the main risks, I would say, usually on the employment side, and this would go for union and non-union workers, is that the government might find that they will do an assessment and they'll apply these characteristics that we mentioned in terms of the test for if someone's an employee or a contractor. And if they are an employee, the employer can be held liable for payroll taxes and other withholdings that weren't done properly over the total length of the employment relationship. So it can be very significant. And what we see, this pops up in two occasions. Either the employee gets audited in some way, or the employee gets dismissed, or sort of the independent contractor gets dismissed, and suddenly wants their cake and eat it too. They were paid for years without payroll deductions, but now they want their notice and severance. And so that's one reason why an independent contractor agreement, I would recommend including express language that says that these individuals have to be remitting their HST and whatever remittances are required for their business, and that you can request proof of those remittances being made. And so it's just that as a little bit of protection. At least you know that there are some remittances being made over the course of the relationship, even if it's not the full remittance or the proper remittance. Great, I hope that answers the question. Another question was, can you give an example of a dependent contractor? So I think we've done that in a couple of cases already. So maybe this question is a little older, but that idea of the taxi driver that just works for you, or as we saw in the motorways case, the truck drivers that only work for the one supplier, and they own their trucks, etc., but they have to go on the routes provided by the supplier. They can only work for them. Those are examples of dependent contractors. And what I usually say is they look like an independent contractor in basically every way, except that relationship with dependents. And there's no right line test on how dependent they are, if it needs to be 100% or 50%. It's going to depend on the facts, but I think anything upwards of 60% is probably pretty risky. Great. This question here about how many agreements do the wage trends represent? Emily, do you want to answer that, or I can try to too if you want? Oh,
I'm not sure what the total number is, but it would be anything reported to Collective Bargaining Ontario. And if you have any interest in the data we reviewed today, want to know more, it's all publicly available on Collective Bargaining Ontario.
Great. And employers and unions are required to report or provide a copy of their negotiated collective agreements to the ministry. And presumably the ministry then enters them into the database. And so that's where these data points are derived from. The reporting is not often stellar, I've noticed, because you can look up past agreements. I noticed it's not always a very fulsome list, but I think it's basically just the best data that's out there, just to answer the question. This question here, temp workers in manufacturing who use company tools and follow company safety policies or work procedures, however, are hired and paid by the agency. Who would be their real employer in a true sense? So that is almost exactly the facts of Lantic. Lantic provided the trucks. They directed the routes. And on the surface, and forced them to wear uniforms, I guess. But on the surface, that's all the control that Lantic had. The temp agency did the hiring. They paid the payroll. They did the training, basic truck training, driver training, and were notionally responsible for discipline. So on paper, that was all it took, or that's how the relationship was. The board also found that the Lantic had effective control over those employees, those workers, by dictating the terms of the contractual relationship between Lantic and the temp agency. It drove the salaries of the drivers, that they can make effective recommendations on discipline and so on. So even though the temp agency had all those sort of hallmarks of basic control of employment, payroll, scheduling of hours of work, and like who would actually go to Lantic versus assigned to another employer, that wasn't enough. The board found that the control that Lantic had over these workers effectively made them employees of Lantic. So hopefully that answers that question. Yeah, there's another question here about bargaining trends. So those trends are just Ontario trends. It's data that we've taken from the Ministry of Labor's website. Like I said, they're derived from notionally all of the agreements that are reached in the province, but probably not a complete list, practically speaking. Let's see, another question here. What is the current practice in Ontario in terms of vacation entitlement for agency employees? If the employee is hired full-time by the employer at the end of the agency contract. So I'm not sure I understand the question, but the agency, if it's a true agency relationship, the agency will be responsible for making sure employees get their statutory minimum vacation entitlement. And it would just be the normal vacation entitlement all employees are entitled to. So 2 weeks per year up to 5 years and 3 weeks after that. There are some specific rules around the hiring of temp agency workers by the client. Okay, I think that's it for us for time. Thanks again so much for joining us. Craig had to jump back into bargaining. He's in bargaining, so thanks on his behalf. And Emily, I don't know if you have any last words.
Thanks for joining us today. Always nice to talk about some recent trends, and we hope to see you next time.
Great. And feel free to reach out to us with other questions or any issues. Thanks again. Have a good day.